in this seminar concerning defending against false allegations of sexual molestation. Sexual abuse has been around since mankind first walked on this planet. It certainly is a scourge, and we wish to rid ourselves of it. But we wish to do so with the proper respect for constitutional rights and appropriate adjudication. For this reason, we're going to talk a little bit about the science and the history of sexual abuse allegations and defending against false allegations of sexual molestation. We're going to start by tracing some of its history.
In order to properly defend against allegations of sexual molestation, we need to understand the history surrounding the child protection movement. There are many things that contribute to false allegations. It all started with the Mondale Act. This law was passed by former Vice President Mondale, then Senator Mondale, and was designed to help the prosecution of allegations of sexual molestation. The law was extremely well-intentioned. However, it had adverse consequences because of some of its provisions. One of those provisions is that it established immunity for reporters. However, it did not establish a means of accountability, which means that if frivolous allegations were made and reported, the person who was damaged by these frivolous allegations could not recover in a court of law. I have had doctors come and tell me that they were afraid that they were going to get criminally prosecuted if they didn't report, and yet they didn't believe an allegation that they had heard. What happens is if you report, you get civil immunity. But if you don't report, you can be criminally prosecuted. And that puts teachers, doctors, ministers, and others under extreme pressure to report, but under no pressure not to report. Therefore, what happened following the Mondale Act was that people started reporting everything, no matter how frivolous, in order to protect themselves. The other problem with the Mondale Act, which exists in every county in the United States, was that money was provided for prosecution of these cases, millions and millions and millions of dollars. However, not one dime was provided for the public defender. This led to a total imbalance of power between the people that were prosecuting these cases and the public defender in charge of defending most of the people charged.
One of the things that we need to remember in the application of the Mondale Act is that although there have been mental health professionals involved in these cases for many, many years, they were not really heard from until we began to see the outrageous kinds of cases that we saw in the late 1970s and 80s. The point Mr. Clancy makes is well taken. Although there's a penalty for not reporting, most courts look past the provision of the law that says the suspicions should be reasonable to be supported, and look past the science which requires only reasonable reports. Mental health professionals have been involved with these cases for a long, long time. Unfortunately, some of the things that have been done by mental health professionals, such as this early book on child sexual abuse, were particularly misguided. This particular book was not based on good science, and it was not based on good empirical evidence. In another example of junk science, the child psychiatrist Roland Summit put out an article entitled "The Child Sexual Abuse Accommodation Syndrome." He explained that this article was designed to discuss things that he was seeing in child sexual abuse treatment. Unfortunately, the article was fastened upon by the true believers, shall we say, the folks that say that children never lie about things of this nature, as a diagnostic tool, an indicator list. The Child Sexual Abuse Accommodation Syndrome has been used in a number of courts as an explanatory tool when in fact it has no empirical basis. One of the quotes from Dr. Summit, which has become a maxim of child abuse intervention counselors and investigators, was that children never fabricate the kinds of explicit sexual manipulations they divulge in complaints or interrogations. This was simply stupid. Anyone that has children knows that that simply isn't true. Children can fabricate all kinds of things.
Roland Summit went on to state that his method was state-of-the-art, highly evolved, intensely specific, and largely unknown outside the fledgling specialty of child abuse diagnosis. What was he quoting when he made that statement? The interviews done by Key McFarland in the McMartin case. the most notorious bad investigation that has ever occurred. He was also quoted as saying, "It was an amalgam of several roles, the knowledge of a child development specialist to understand and translate the toddler's language, a therapist to guide and interpret interactive play, a police interrogator to develop evidentiary confirmation, and a child abuse specialist to recognize the distinct and pathetic patterns of sexual victimization." These were the quotes from an article in which Roland Summit discussed the interviews of Key McFarland. In fact, there was no scientific basis for what they were doing. What happened to scientific methodology? There were no control groups. There were no validity studies. Reliability was not even considered. Error rates were simply overlooked. According to the Child Sexual Abuse Accommodation Syndrome, if a child is sexualized, they've been molested. If they are withdrawn, they've been molested. If they tell a consistent story, they have been molested. If they tell an inconsistent story, they have been molested. If they retract, they've been molested. If they don't retract, they've been molested. In other words, all roads lead to Rome. All outcomes are that molestation occurred. Nowhere in the writing about the Child Sexual Abuse Accommodation Syndrome do we see anything that could be interpreted as being a false allegation. One of the biggest problems of the Child Sexual Abuse Accommodation Syndrome, and a lot of the work that the early mental health professionals were doing, is they forgot their scientific training. They forgot to look at the difference between diagnostic sensitivity and diagnostic specificity, sometimes known as the logical error of affirming the consequent. Let me give you an example. All pregnant people are females. This person is a female. Therefore, she is pregnant. Totally illogical. And yet that's exactly the premise upon which the early work was done, and the child abuse accommodation in particular was founded. Here's another example of the fallacies of this type of logic. Let's assume that there's a head of surgery at a hospital, and his orientation is that prostate cancer is the scourge of the world. He develops a new surgical protocol. The surgical protocol is that he will perform surgery on all men over 40 and remove the prostate. This is a very sensitive test for curing the perceived scourge. By simply removing the prostate of every man over 40, we eliminate 99% of all prostate cancer. Okay, would all you men in the audience please stand up and go to the waiting ambulances? Of course not. Why? Because most of us do not have and will never develop prostate problems. The problem is that this test or protocol is very sensitive. However, it is not specific. 95% of all males over 40 do not and never will develop prostate cancer. Can we operate on 100% of them? Should we operate on 100% of them? If we did, that would be a 95% error rate because that test fails to look at the issue of specificity. Would you let a surgeon with this type of protocol work on you? Would this be good public policy with a 95% error rate? The test is sensitive, but it is not specific. And that is the problem with the child sexual abuse accommodation syndrome.